Now I request to please start the session.
Thank you very much. Okay, welcome all to this session today, which is a continuation of yesterday's session. Yesterday, we dealt with the amendment bill and the provisions in that. Today, we are going to deal with primarily two topics. One will be the amendments which have already been notified in the CRP regulations during the current year, that is 2025. We will also cover very briefly the amendments in the CPE guidelines, which have been recently notified. This session we will have as a completely interactive session. It's 100% interactive. Participation is not only welcome, it is actively encouraged. Any participant can interject at any time with a question or a comment. Uh, the only request is please follow the methodology of using the raised hand symbol, which is there in the bottom of your screen, and everyone will be recognized and allowed to speak. So without further ado, we will go to the first segment of today, and that is the amendments in the CRP regulations, which have been carried out in the year 2025. A lot of these amendments, not all, but a significant portion deal with the real estate sector insolvency. Uh, Over the period of last 7-8 years of IBC, it has been noticed that one, real estate insolvencies probably form the number one chunk in terms of from a particular sector. Two, they are characterized by a large number of stakeholders in the process who are effectively a vulnerable section, that is the home buyers or allottees. And obviously they have their limitations in terms of understanding, limitations in terms of resources that they bring to the table, and also the fact that they are among, if you look at the Section 53 table, probably the one who are hardest hit in terms of uh, how the insolvency affects, along with, let's say, workmen also, workmen and employees. Uh, and the real estate sector also has its own peculiarities as compared to other sectors. It is also governed by another law, that is RERA, which is the primary sectoral law. So there is an interfacing between insolvency and RERA, and how the RPs navigate through this to ensure that the rights of stakeholders are protected. So with the experience of this last 7-8 years, IBBI has notified these amendments, significant number of which relate to the real estate sector, which have followed intensive discussions by way of discussion papers with the public at large and also private consultations. Okay. So now we will go to the first one, and a very important amendment in when you look at it from the viewpoint of allottees, home buyers, that there are many cases and many instances where a home buyer might have paid the entire consideration or willing to pay the balance, if any. The construction is completed. The requisite permissions have been received, completion certificate and occupancy. But insolvency hits in between, and possession transfer or handing over of the plot or apartment or building, as the case may be, gets stuck. Uh, the law was IBC law was a bit unclear on this because there was no specific provision in the code or regulations how to deal with such a situation. And going by the experience of the last 7 years, this is the amendment which has been now implemented, okay, in terms of the amended regulation 4E. It has put a few small conditions that the handing over of possession shall be with the approval of the COC with a 66% majority. And what is handed over is not just the physical asset of what is a plot, apartment, or building, but any documentation, that's the word used is instruments, which are agreed to be handed over at the time of when the allotment had been booked by the allottee or allottees concerned. This might include, depending on the situation, even the conveyance of the underlying land when the building is, say, let's say the company is in insolvency, but one particular project, which is standalone and separate, has been completed and all that is remaining is handover, then the entire process can be completed by the RP with the approval of the COC with a 66% majority. Any questions? Or comment or experience? Okay. Okay. If no question, then we will go to the next one. Yes, Muniji.
Can you elaborate on this performed this part under the agreement? Now, let us say there was an agreed amount of 1 crore rupees to be paid. The situation can be 90 lakh was demanded and 90 lakh was paid. 10 lakh still remains to be paid. So, is that 10 lakh can be demanded now by RP and he will pay it and it will go to CD? And a connected and follow-up question. In case assets are mortgaged, duly mortgaged, when I say duly means section 11H of RERA taken care of. They are mortgaged before or with permission or before 10% consideration were taken. And there is a charge existing on the assets. What happened in that? There are two connected questions.
Okay. So the first one is about specific performance of the contract between the buyer and seller. Seller being the CD, buyer being the allottee or home buyer. Now, handover in the insolvency situation is when all obligations of both sides have been completed. Okay, so from the seller side, it will be getting the requisite permission. No handover can really happen if you don't have a occupancy certificate, for example, if the local law says so. So that is the seller side obligation. From the buyer side, if any amount is left to be paid as per the original terms of the booking or allotment, that has to be complied. No handover can be done if even one part of that obligation is pending for whatever be the reason. Now what happens to that money? That money comes into the corporate data. And second question, that's I understand that is related to the first. What if it is mortgaged? Okay, all assets in every insolvency tend to be mortgaged to some lender or the other. So during insolvency, okay, let us understand it this way. For a real estate company, while the flat or a building might be otherwise immovable property, for the purpose of the accounting in the real estate company, it is inventory. So selling of it is normal course of business. It is not transfer of a immovable property per se for the purpose of that business. In another law, it is immovable property. That is understood. But for the corporate debtor, it is not a part of his fixed asset schedule. It is a part of their inventory. So it is any transfer will be considered as transfer in the normal course of business. And while it is a mortgage, it is as good as a floating charge on current asset, as good as. Does that answer the question?
It does. Then I have a follow-up question. Let us say the total value of assets mortgage is 100 CR. I have a charge on 100 CR assets. My lendings are, say, let us say 50 CR, 60 CR. Now, during CIRP, does he need my NOC to get this registered? One. Two, if not, suppose 90% owners or allottees get their flats registered, the my security comes down to 10 crore rupees. And imagine that company goes into liquidation after that. There is no guarantee it will be resolved. It goes into liquidation. Then I am adversely affected as a secured lender. So where is my protection as a mortgagee?
Okay. Uh, while you are a mortgagee, in this case, as I said, it is more like a floating charge for the purpose of that business, not in its hyper-technical sense, but in terms of the implementation. So let us treat a flat here as equivalent to a car by automobile manufacturing. No difference as far as the treatment of the lenders is concerned. Now, the money that comes in, naturally, that will remain in the company and that will be distributed at some point of time as per Section 53, as and when required to be done. That will be done. At that time, this priority of charges, etc., is to be considered. Uh, Obviously, this money, because it's a realization by sale of asset, whatever be the type of asset, can only be used in terms of the law under IBC, which allows usage of that, which means maybe for certain CIRP costs, but otherwise not for anything else, unless the COC approves such a usage. If such a, let us say, company goes into liquidation, what happens to your mortgage? Like any other, you have a charge. Things can go. Businesses, current assets are gone even during CRP, but they have been converted to cash. So effectively, there is no loss. That the asset has got converted into cash, and now the cash will be available for distribution. So there
What
is no.
happens? What happens if I don't have charge on the cash part? I don't have
No,
charge on the
you don't need
receivables.
to. Yeah, okay.
Hmm.
See, if you have a charge on any particular asset and that asset gets converted into cash, your charge continues even though it is not specific. It doesn't have to be. Any realization from a charged asset by an RP, receiver, liquidator, by whatever name you call them, are to be held in trust for the benefit of the charge holder in terms
So,
of the applicable law.
so to that extent, the issue of interpretation would arise, and RPs can take different opinions. So,
Yes, well, IBC is relatively new law. I mean, just as an example, if I have to give, the Code of Civil Procedure is more than 100 years old. And even today, after more than 100 years, we still have at least one judgment coming from Supreme Court on an interpretation of a CPC provision. So, ये चलता रहेगा. People will have different views. There might be different interpretation which is specific to that circumstance. But that cannot be general. The general principle would be rights are protected.
so the mortgages and lenders can challenge this proceedings of COC.
No, there is no question of challenge. First of all, they have to be part of the agreement. Even if, let's say, they are in a minority, that can happen. And the majority, let's say, are unsecured lenders and they give permission. Very, very possible. But they have to see, IBC says will of the majority shall prevail. It has to. But they are not going to be adversely affected because that cash which is realized from the transfer of that asset is still going to be remaining in the company and cannot be used for any purpose, any distribution purpose.
Okay.
Any other question?
No from my side.
Okay, so next one. This is a big regulation 16C and D in terms of size, but possibly very unlikely to be used except in a very minority of cases. Because this regulation 16C and 16D, which deal with the concept of what is called a facilitator. These are basically helping hands for allottees when the number of allottees exceeds 1,000. Okay. So chances of such projects are likely to be very less. There will be, but they will be a handful. The vast majority of 99% plus will not fall within this. But still, there is a provision made that one AR, it will be overwhelming for an AR. Suppose if there are 1,000 allottees or more, in some cases there have been 25,000. What the poor AR will be helter-skelter what to do and what not to do. So there is a provision to give assistance to the AR. So the facilitators are a bridge between the authorized representative and the allottees. Now, who are these allottees? They are not all of them. So there will be subclasses. Each subclass has to be a minimum of 100. Okay. 100 or more allottees together can seek appointment of a facilitator who will be the bridge between them and the AR and the committee subsequently. Uh, these could be, while no conditions are placed in the regulations, but they will tend to be, let us say, the same tower or the same group of towers if it's a large project. Or if there are many projects, then project A will have one facilitator, project B will have another, etc. I mean, this is good. Are the way subclassification can be done. The regulation says it has to be a group of 100 or more who have to come together to seek the appointment of a facilitator. Now, facilitator can be an IP, but need not be an IP because it says any other person. It could be somebody else. The name of the facilitator is to be recommended by that subclass of 100 or more, and the appointment will be done with the approval of the committee. Now, there is an upper cap that the total number of facilitators, irrespective of the number of allottees, shall not exceed 5. So, if there are 500 allottees, for example, it will be 5. But if there are 5,000, it will still be 5. That is the maximum cap. Okay. Then we will cover the duties and then we will take questions on that. So, what is the job of the facilitator? Like a bridge, communication bridge between the AR and the creditors of that subclass. Now, there are all allottees will have certain common issues because of the insolvency and and in relation with the corporate debtor, but they may also have project specific or subclass specific issues. And this is where they now get a voice individually. Otherwise, during voting, it is present and voting system, and many of them get overwhelmed by the proceedings that go on and are not able to put across the issues that they have. So this is a mechanism where subclass of allottees can also get their specific issues heard and represented in the committee through the facilitator, AR, and them. The facilitators are allowed to attend the meeting of the committee. I mean, they ought to attend, but only as observers. Okay. They won't have any right to vote. And they will be the ones who will provide information and clarifications to their subclass allottees about the process, CIRP process, as per the advice of the authorized representative, which means that the communication which is specific to that CIRP, they will have to coordinate that the messaging which they give and which the AR intends to give are both on the same page. Any questions? Comments? Experience? Okay. We get to the next one. Again, this is related to real estate. This is amendments in the regulations governing meetings of the COC. Now, it starts off, 18.4 starts off with where the CD has a real estate project. So, very real estate specific. The RP may be directed by the committee to invite the competent authority. Now, the competent authority, the definition is to be picked up from RERA. It is usually the local authority which has jurisdiction on that particular real estate project in terms of regulating it, like in terms of the plans and permissions and things like that. So it will be different. It could be the municipal corporation in a particular place. It could be in North India, for example, the Noida Authority is one such, or a greater, Ghaziabad Development Authority, or MIDC in Maharashtra, something of that nature. Whoever is designated as the competent authority for that particular project, which means that project has gone to that authority to seek its permissions, that the RP could be directed to invite such party, their representative, to attend meetings of the Committee of Creditors. Not all meetings, only such meetings where the committee feels their presence is useful and their inputs will be valuable in the process. So this presence is a participative status, but not as a member, so no voting rights. Similarly, in the same, they have also talked of similar facility to be extended to the providers of interim finance. Again, not for every meeting, only those meetings which the committee or the RP along with the committee feel that their presence would add value to the proceedings. Any questions? Okay, either I am very, very clear or there is nobody present. One of the two. Okay. This is going to be the most difficult one. So better to pay attention to this because this is directly addressing duties of the RP. That where a CD has development rights and permissions of real estate project. So the heading itself sort of indicates that the land per se is probably not owned by the city for whatever reason. It could be a leased land. It could be a land in the name of the promoter or any one of them individually or some other entity. It could be land given for development rights by third parties. So it could be any of those. The idea from the regulation would be that probably this is not talking of where the CD owns the land, because then it is not a development right that is being the asset. It is the permission to build the project. But if you look at the second part, it says permissions of real estate project. So maybe that is also covered. And to be on the safe side, it is better to assume that it covers both situations. That where the land is not owned by the city, but only development rights exist, or land which is owned by the city and there is a permission for executing a real estate project. So what is the duty? So the duty of the RP is to prepare a report detailing the status of development rights and permissions required for development of such project. So that's like a status report on what is it today. Submit the report to the committee, that is the COC, for its comments, and after receipt of such comments, submit that report with the comments to the NCLT within 60 days from ICD. Now, this is going to be a challenge. Please note the word shall. It tends to be mandatory. And one should be careful on these matters because this is directly adding to additional work for the RP within a defined timeline. Not that it doesn't have to be done in normal course, but now the timeline available is only 60 days. Any questions? Okay. I presume I am audible, and that's not a problem.
You are audible, but then there is again doubt. This is only where you have a development right or where you are also a landowner. So what do you think? Not rights and permissions, not rights or permissions.
Yes, and no, while it says status of development rights and permission. So if you look at the regulation, it probably implies that it is for both situations, and that would be the correct interpretation. Because what is the for? It is firstly for the benefit of the committee that they know what is the state of affairs of this particular corporate debtor in terms of the their various projects, one or more, what they have. And of course, submission of report to the adjudicating authority would probably be for record purpose at that stage. but also to compare with the plan, if any, at any subsequent point of time, and also aid the adjudicating authority in tackling any applications, IAs, that might be filed by either allottees or promoters or whatever in relation to this. So they will have a document which is authenticated by the RP, which gives in one place all the situations about that. It is like a statement of affairs in a normal company, but in this case, it is real estate specific. Uh, if you ask me, I would say you assume that you have to do it irrespective of the status of the land, whether it is owned, leased, or whatever, it doesn't matter. Do it. Okay. And in the end, it will help the RP more than anybody else. Because then when the plans come, it will be so easy to compare them with respect to the state of affairs that is already existing. It will help in preparing the IM, and it will also help in preparing the RFR. Okay, IM. This is an addition uh, of giving details of the avoidance transactions, identified avoidance transactions, including fraudulent or wrongful trading. Now, the amendment bills also clearly distinguishes between the two under the broad heading of avoidance. And also about filings, subsequent filings before the adjudicating authority. So now question will be details. Okay, details not defined. What are the details? But one would assume that what is the subject matter of that application? Against whom has it been filed? The names of the parties, the amount involved, or the property involved, depending on what it is, and what are the prayers sought. And as regards filings before the adjudicating authority duty, I would assume, okay, IA number, etc., naturally, mandatorily to be given, date of filing to be given, and the status as on the date of making that IA. My understanding here is that the copy of the IA is not to be part of the IM. Not necessary. But that's just my understanding. I don't think there is any ruling on this aspect, as far as I know, by any of the benches. Now we come to 36A, invitation for expression of interest. This is the consequence of the Form G. We do tend to make this mistake that Form G is the EOI. No, it is the invitation for EOI. It's just a public announcement of the invitation for expression of interest. Now, this is an addition. The RP may, with the approval of the committee, again, invite expression of interest for submission of resolution plan for the city as a whole or for sale of one or more assets of the corporate. Now, most of you, I'm sure, will recall that this already existed. What is new? Actually, there is nothing new except that it was parked in the wrong place. Now it is parked in the right place. It has been deleted from the RFRP and put where it ought to be, that is at the EOI stage. Otherwise, it was existing even before 2025. What is added is, of course, 4E, and that is the details of this registration status of the corporate debtor as an MSME, as on the date of that, us seeking that EOI. Whether it is registered or not, if yes, if registration number, etc. And in what category? Is it micro, small, or medium? Again, a special proviso for real estate projects, that where the city has a real estate project, the committee for an association of a group of allottees representing not less than 10% of the total allottees or 100, whichever is lower, may relax certain conditions for in relation to giving an expression of interest. One is eligibility criteria. Now, this eligibility criteria is the standard eligibility criteria about net worth and past experience and things like that, which we design in our document, invitation to for EOI document. It obviously does not include 29A. Okay, this is my interpretation because it's talking of a group. So it is assumed that that group would be 29A eligible, but again, not sure. It could be that it is a group of people who are related to the promoter. Will they be considered even if they form an association for which is effectively self-development to be adjudicated? I would say park it, not sure. I am not sure myself whether that will be 29A would still apply to them. But other eligibility criteria, which are non-statutory, contractual criteria as decided by RPA along with the COC, those can be relaxed. How much, which one to relax, entirely left to the committee. Similarly, the refundable deposit, EMD, what we call at the beginning, which we tend to ask for, that also can be relaxed. The relaxation can be in terms of the amount, which can be at a discount or rather a reduction from the EMD for which is applicable to others, or it could be a complete waiver. That discretion again left to the committee. Now, there is one more thing, and that is the performance security. So that is addressed in the request for resolution plan, because only after getting a PRA's list, then this part comes in. So that also can be relaxed. How much relaxation, to what extent, in what manner, left to the committee. Okay, again, the same qualification that that association should be comprising of at least 10% of the creditors in class, or 100, whichever is lower. That continues throughout the real estate related provisions in the IBC. I had mentioned that one regulation was inserted in the previous one, and the same one which was here, wrongly here earlier, categorization wise, has been deleted.
But there is slight change. In 36B6A, it was once you fail one stage of FOMG, then you don't issue a plan, then you could invite asset
Now
price
you
or
can do
budget.
it in the beginning.
In the beginning, that's the
Right.
change. That's the change.
And now it is going to hopefully, in the amendment bill, it is going to get a backing from the Act itself.
Yeah.
Okay, mandatory contents of the resolution plan. There is a significant change or rather clarification. Now, this part is the clarification part. This was always the intent, but there was some confusion because it is not specifically provided for. The code says that the dissenting financial creditors shall be paid before payment to the assenting FC. Now, what happens in a situation where the assenting FCs are paid in parts for a period of time? And sometimes it could be in years, maybe 5 years, 10 years also. There is one plan which was approved with a 20-year payout. Now, in that case, should the dissenting FC be paid its entire share, whatever is there, upfront before the first installment to an assenting FC? The logic said no, it ought not to be. At every installment stage, they should get first. But the clarity was missing because people had doubts. So that is now clarified that at the precedence or priority of payment is at an installment stage wise, and also clarified that it should be in the same proportion. So if the second installment, for example, first is 10%, then you have to pay 10% of due to the dissenting FC also. If the second installment to assenting FC is, let's say, 15%, then even the dissenting one will get 15% of the total. Any questions?
No.
At this rate, I think we'll finish in 1 hour. Then you can relax for 2 hours. Okay. uh, Continuing on the mandatory contents of the resolution plan. Now, this is negatively worded, that a resolution plan shall not provide for assignment of any avoidance transactions with that were not, okay, which don't fulfill it, disclosed in the IM. So if you have not disclosed about assignment, avoidance transaction in the IM, the resolution plan cannot have a provision of assignment to anybody. Okay. So disclosure and intimation to all PRAs before the last date for submission of the resolution plan. So this condition was not there prior to this amendment. Now it is mandatory that this is about a level playing field and prior disclosure, so that there is no possibility of a collusion between A and B or whatever, and somebody gets an undue advantage as compared to the other players in the field. So it sort of plugs a loophole in a way.
Should it not be few days before the last date? Today is the last date, and I inform him at 11:59 on 3rd of September. How does he change his plan
How
overnight?
does he? Okay. So this is like talking like a lawyer. Good.
I'm a lawyer.
But I would say one has to go by intent here, that it has to be sufficient notice, because what is reasonable notice is what you call an inherent right of every person in any proceeding. Reasonable notice.
The regulation
1
does
minute
not talk
cannot
of
be
any
reasonable.
reasonableness of notice. You say just before last date.
Yeah, I know that. But what I'm saying is that it's not necessary that for the law. I mean, ought to have been, let's say next time if some such thing come, they will do it. But I would say that, as IPs, we are becoming a bit too hyper technical on these issues and missing the wood for the trees. Uh, One should understand, if you are on the other side, what would you expect? Do the same thing to the other person. So instead of an RP, if you are an RA, how much notice would you want? Give the same.
What I intend to convey is that scope of collision between A and B still exists.
Oh, so you get all the most intelligent people in the world to draft a law. There will be somebody more intelligent who knows how to break it. उतना नहीं कर सकते. Okay. I mean, one can always say ये भी होता वो भी होता. Then, if all the possibilities are taken care of in any law, then the document would be minimum 300 400 pages. Then we will say, oh, it is too big and it is too complicated. इसको छोटा बनाओ. छोटा बनाएगा तो something will be missing. I would say this, it is expected that RPs are rational people, and if they do such thing, that would not be reasonable conduct in terms of the code of conduct. So they better beware. There is IBBI to take care of such things.
And between subclause A and B, should it have been or instead of and? Between A and B.
It is and, not or. And it is deliberate. Okay. See, IM is given at one point of time. First, IM is given to whom? It is given to the COC. Okay. They are the first recipients of the IM. So it must be included in that. Okay. That is the source document effectively in some manner for the next part, which is invitation for EOI, etc., etc. And because the PRAs come at a later stage, so it is and they should also be told.
Now, the fact is, I give IM to PRAs also. If I have already given them IM, why does the requirement?
Why do you need to intimate them separately? Yeah. See, this is being doubly sure. Is it essential? No. But if we look at our any law, there are so many things which we repeat. Take any contract, 5 बार तो हम repeat करते ही हैं. So we are habituated to writing long answers in school. वो आदत जाती नहीं है. to
Or is it a drafting error and we are just trying
it's
to
not an
justify
error.
and here?
See, if there is at this stage you will give and also at this stage, that's not an error. That is, you can say overabundant caution,
I
but it's
don't
not
know
an
how
error per
many,
se.
I don't know how many RP will read it in this fashion. They'll
See,
assume if you are given in
let us
IM, you
let
have
us
to
let
give
us
it.
do like I mean think like this. It has to be done in the IM, and IM is given to PRA. So the PRA is anyway intimated via the IM about it. Even if B is not done specifically, it is not a fatal error. This is like drawing attention.
We'll discuss it offline.
Ah. It is not a fatal error in the sense that once you have included in IM, that is the moment you give that IM, which includes this data to the party, then that they are aware of it from the
Now,
IM or ought to
now
be
you
aware
now,
of.
now you are leaning towards or.
No, no, not or. I'm still saying it is and because they are two different stages. Okay. So that's why it is and. Suppose you have in the IM, that is because that is for the COC. कि ये है. Okay. You may not have a PRA because your Form G might fail. In which case it still needs to be in the IM. Okay. So it's okay. It's not a error. Abundant caution maybe, but not definitely not an error. Okay, and now this is a regulation where the regulation has followed practice. Much before the thought of having such a thing came in regulation, years before, probably one of the earliest resolutions itself. The concept of a monitoring committee, by whatever name, some people used to call it steering committee, some call it monitoring committee, some would call it monitoring agency, etc., has already been in implementation for more than 6-7 years. So now the law is just formalizing custom in this case. And of course, when they make it, they also try to fill up any understanding gaps. So it is not mandatory to have a committee, but it is mandatory to consider whether there should be a committee or not, which means that from an RP's perspective, this has to be an agenda item at the time of approval of resolution plan. That does the COC want a committee or not? If the why is this that it should consider, but it's not mandatory? There may be a plan which is 100% upfront. You don't need a committee. Take the money and hand over the CD. For smaller, especially smaller resolutions, there may be no need of having a committee. It can be directly done by the RP within the first 30, 40, whatever day period is sought by the applicant for making that payment. So they have to consider it. It means it has to be in the agenda and it has to be minuted what is the decision of the COC, whether to have it or not have it. Now, if they decide to have this monitoring committee, so it may, now the may comes, consist of the RP or any other IP or any other person. So unlike AR, which is a sort of a statutory position, the monitoring agent or whatever name you call that person is not a statutory person, it is an optional thing. And why other than an IP? The implementation part might require, for example, not so much IBC knowledge as domain knowledge of that sector, which an IP may not have in many cases. So the committee is free to consider somebody else who might do a better monitoring job for whatever be the period. So entirely left to their discretion. It may also include representatives of the committee. So it is representatives, but it can be the whole committee if the number is small, or it could be just restricted to a few of them. And where the RP is proposed, now the limitation provision that the fee of the RP shall not, as a monitoring agent, shall not exceed what was being drawn as an RP. So that is the upper cap. And The monitoring committee now is required to submit quarterly reports to the adjudicating authority. So even if the order of the A does not mention anything in relation to monitoring committee, when they approve the plan, now it is a mandatory duty that if there is a committee, they shall submit quarterly reports. Now, this is an important change. In 39, this is at the approval of resolution plan stage. Till the other day, RPs, in a way, were assuming that they have discretion to reject a plan for non-compliance and not even put it across to COC for consideration by just simply saying, okay, with reasons, let us assume that this plan is non-compliant for reasons X, Y, Z. Now that is not allowed. The RP has to submit all plans to the COC, flagging the details of non-compliance of those plans, which in the opinion of the RP, they are not compliant with whatever is the code and regulations. So the discretion of which RPs were trying to exercise has now been removed. They have no discretion about rejection. So it is the same thing that you don't have adjudicatory power in a way. You can only flag what is that. That portion, part of it now has been that duty and power has been transferred to the committee, because the committee now shall mandatory evaluate only those plans which comply with the requirements of the code and regulations. Now, why both are there? First, it's a check by the committee that RP's conclusion about compliance or otherwise, that is being checked by the committee that it is right. And also, though it is not specified here, but I would assume that is an intent that the committee may decide to give time to such RAs whose plan suffers from non-compliance, which is curable. So give some time to cure those provisions or whatever. I presume that is what is the intent. Of course, within the overall timeline, that is considered to be sacrosanct. Any questions?
When non-compliant plans are put up to COC, so they take officially some decision through voting, or they just take note of it?
No.
What should be the practice?
The decision of compliance or non-compliance is not a voting item, ever.
No,
It
no,
has
no.
to be based on
Okay,
facts
let me reframe my question. I was attending a COC meeting yesterday. And then RP has put up received four plans in that case. All four are non-compliant. So RP has given his report that I received four plans and all four of them are non-compliant. So the issue was whether they should just take note of it, move to next stage, or they should be further evaluating RP's due diligence done and put up some voting mechanism, because all four plans are non-compliant.
Yeah.
And
Okay.
non-compliant means they were badly non-compliant.
Fine. It can be. That's possible. Okay. Let us look at the role of the RP. The RP, in the beginning of implementation of IB, RPs thought that they were the Karta Dharta, all powerful. Today, a lot of IPs think we are sort of clerical, our duty, and we are not expected to exercise or give any stress to our brains. That is absolutely wrong. The IPs should realize that, like any other company, if you're working as an employee, and even if you are the managing director of that company, you still have to report to the board, and board is above you. So take that into account. But The board would normally expect the CEO to also guide it, give his opinion, report, as good as what is curable, what is not curable. That the RP is expected to do. That is the job of the RP. Examine the plan, give a report. Okay. Even if it is non-compliant, what are the details of non-compliance? Which of them are fatal, which means with that being there, nothing can be done, there is no possibility. And which of them are curable? Or sometimes one can say, okay, there is so many non-compliances in this plan, it has to be redone fully. Now this committee, this is where the discretion of the committee comes. Everything need not be written in the code. That would be spoon feeding to the highest order, not expected with adults. The committee is now, with the guidance of the RP, required to decide, taking into account at which stage of the process they are in. Timelines are important. Should they give time to the RAs to cure the defects? If so, how much time? That can be done. That is what is expected to be done. Okay. Plans, when they come first, need not be compliant. Even if you get it made by the best law firm in the country, I'm sure there will be somebody who will find at least one mistake in that, which is important. May not be fatal, but important. So it is expected that the RP actually starts behaving like a CEO and not say कि ये लिखा नहीं है तो मैं नहीं करूँगा. The RP is the friend, philosopher and guide of the COC. Doesn't need to have voting share. They have to act like that. And that would require study, preparation and knowledge. And of course, the willingness to assume that role. So where you have IPs who are in line with this sort of a role, these questions don't even arise because they are tackled. They are foreseen and tackled. Any other question?
The 2018 charge of duties and of IP and COC has become old. We need to revise it now.
Yes. Naturally. Yeah. 7 साल, the 7-year period has passed.
उसको रिवाइज करके भेजना पड़ेगा.
Yes, yes. True. Any questions? Anybody else? I'm guessing nobody else is there. They have just logged in but not attending. So we will proceed.
No, we are here, sir.
अरे पूछो
Listening
ना
to
कोई
you.
सवाल. Put me in trouble, no? A little. थोड़ा मुझे भी तकलीफ दो.
अरे कल मैं ही सबको पूछ रहा था, इसके लिए मैं बोला आज मैं खुद बैठता हूँ.
अच्छा.
We all are listening to you, sir.
छोड़ो कल की बातें. कल की बात पुरानी.
ठीक है. रियल एस्टेट में मेरा कोई ऐसा एक्सपीरियंस नहीं है, तो इसके लिए मैं ज्यादा कुछ सुन रहा हूँ.
Most of these amendments deal with real estate, except what we are now talking.
No, अभी what you were talking about, अभी recently यही है. I will share one experience. Recently, I had concluded a COC. So where the question put to me by COC was, why are you even putting a non-compliant plan before us? Why do we have to take a call on this? So I said, देखो भाई अभी regulation बदल गया है. You will have to take a call. You can decide whether you want to ask the fellow to cure whatever can be cured, Of course, in this case, there were a couple of curable things,
Right.
So we told that fellow ki bhai, it cannot, this is looking like a contingent plan, so you have to remove that, otherwise this cannot be considered a conditional plan, not contingent, conditional plan. Okay. So then it is up to that fellow whether he wants to do it or no. I said, but that you have to say, not me.
Correct.
I have to present before you. So ultimately, ठीक है, they did it. But COCs themselves, is basically in, I don't know about the real estate cases, but most of the cases, the COC, particularly when there are banks, no senior officer as such comes. So many a times during the CIRP, officers also change. So the practical thing is okay. They have put it before the COC, but now even they're in the proposed amendment, they're putting this 29A, this thing also before the COC. To my mind, it will be a little limited purpose, but anyway, ठीक है. One way it is good for the RP that it is minutized in the COC.
Yes.
So to that extent you are safe. Nobody can say कि आपने बताया नहीं.
It will be a collective decision and not a unilateral decision.
Yeah. But it's not even a decision of the RP anymore. Na? It is entirely the decision of the COC.
No, in the 29A, the proposed amendment doesn't say COC will decide. It says COC shall discuss and its deliberations shall be recorded.
And do what? Can the COC discuss?
No.
And
If the
say,
COC has a conclusion that it is not, then naturally between the two they have to discuss what to do next.
Yeah.
That
So
everything
that's what.
cannot be put in the law. Otherwise, the law will be 5,000 pages will fall short.
No. What happens is when you are saying something, like in case of RP, things are pretty clear. ये कर सकते हो, ये नहीं कर सकते हो. Everything, see, can a COC accept a person who is not a 29A compliant? They can't, right? So, just a discussion and recording.
No,
क्या होगा?
it's got value. It's got value because I'll tell you what is the intent behind it. The intent is to avoid the possibility of any collusion. So there is a check. That means RP is saying these are compliant, these are not 29A as per whatever I have done. And COC looks at it and says, okay, this is fine. Or they say, no, this one you have rejected. They can discuss with the RP. What is the basis?
No, they are not rejecting. See, 29A
Rejected,
also,
or you
today.
said this one, if you say flag somebody as not compliant under 29A or not eligible, then the COC has the right to seek from further information from the RP.
See,
So
even
about
today,
the basis.
I think without this regulation also, even today, when you are putting anything before the COC and if you are saying this particular person is not eligible, you are actually giving either a independent legal opinion or your own study, something or the other, you are anyway putting in the before them. Now, अब you discuss करके, unless they say कि now you hire someone else to do it, वो अलग बात है. Whether that is the
They
intent.
that discretion is left to them. And I think we have discussed this in some other forum that the amendment
Basically all the amendments, whatever they have done, they basically, the primary intent seems to be that rule out the possibility of any collusion between the RP and the whoever.
Yes.
Now,
that is there.
So,
and so that is a very important intent. It is the thread running through all the amendments, not just one. Almost every
precisely
one of them, that is the underlying thread.
So if you look at ArcelorMittal, from the days of ArcelorMittal, Supreme Court has already said that RP can only say a party is eligible or not eligible under 29A. Based on 29A, he cannot reject the resolution plan. The decision has to be in any case taken by COC.
Yeah, so RP doesn't anyway do it. Actually, RP के पास power है ही नहीं कुछ reject करने का.
That's what Supreme Court
था.
clearly said in ArcelorMittal. Okay, you only say eligible, not eligible. The decision lies with the COC to reject on 29A. RP cannot reject.
Now question is, let us say RP has given an opinion or some external opinion he has taken and he has put 1, 2, 3, 4 reason why this person is not a 29A compliant. Okay. Now, for whatever reason, COC feels no, he is 29A compliant. They also put through their whatever note. Why they feel the 29A. Let's say in an extreme case, who prevails? If the RP is now presenting that plan to the NCLT as approved by COC, does RP also say कि my due diligence says he is not 29A compliant, but COC told me to nevertheless put his plan?
Sir, in this situation, I would like to share. It's a
Yeah,
dual
please,
approval process.
Gotcha.
Approval process. So first, it is required to be approved at the COC. So far as resolution plan is concerned, RP is not the deciding authority. It's the COC where the first approval takes place for resolution plan. And
Right,
then
right.
it is the NCLT, the second approval. So at
Right.
NCLT level, RP can definitely say that as per my view, 29A is not compliant. COC is still approved it. So NCLT will then take the cognizance of it, and second approval it will not be given if it is not compliant with that. Only my concern here was about, earlier what the fundamental was, COC level, what the approval was based on the commercial wisdom mainly, not the compliance of applicable laws. Whereas NCLT should take care of the compliance of applicable law. Now even COC is
Yes,
required
you're
to
right.
see the compliance of applicable law. That is where and whether the COC has that wisdom to see the compliance of applicable law or the compliance of code and regulations. So that is a new challenge that committee, it's this authority which has been given. No doubt it's a dual approval process. So ultimately, NCLT will decide on it. But this is something to be, COC has got a new obligation.
And that's what, that then it must be said that despite somewhere in the regulation or the act, whatever, it must be said that if COC still feels for reason that this particular plan should be approved or considered, then the COC should record its reason in writing.
Okay, on this subject, let me just add a little.
Yeah.
First, it is a part of the amendment bill. It is still not an act.
Precisely. Okay.
Okay. Then the amendment bill itself provides that manner, etc. of doing will be by way of regulations. So,
Right.
So regulations, I'm pretty sure with all the feedback that IBBI gets, they will address some of these issues to the extent possible. So we will be speculating about regulations when the act itself is not passed.
Yeah, I think they could have instead of saying regulations, they could have possibly put it in the rules, which is to be passed by the parliament. That has better sanctity. Because what has been happening, sir, आप देखो,
ऐसा कुछ नहीं है. हाँ.
आप देखो सर, जो भी रेगुलेशंस इन्होंने बनाया है, बहुत से जगह पे आईबीबीआई ने तो रेगुलेशन बना दिया, पर पिछले 8 साल का एक्सपीरियंस ये कहता है कि कोर्ट में जाता है, फिर वो अल्टीमेटली वो बोलते हैं ये डायरेक्टरी है, ये मैंडेटरी नहीं है, द सबऑर्डिनेट रेगुलेशन कैनॉट चेंज द मीनिंग ऑफ द एक्ट, विच इज ट्रू. प्रिंसिपल एक्ट को एक्सपैंड तो नहीं कर सकता है, हाँ, बट इसके लिए जितना क्लैरिटी एक्ट में आना चाहिए, या
एक्ट होगा 5,000 पेज का.
5,000 पेज का जरूरत नहीं है सर.
नो, बिकॉज एवरीबडी विल हैव कि ये भी मेरा डाल देना एक्ट में.
सर देखिए क्या है, कंटेंशियस इश्यूज कहाँ आ सकता है. अब अगर या तो आपका 5,000 पेज का एक्ट होगा या 5,000 पेज का रूल्स होगा, रेगुलेशंस होगा. हर 6 महीना आपका नया रेगुलेशन आता रहेगा.
See, it is assumed that the act, rules and regulations assume a certain minimum level of intelligence of the people who are required to implement it.
No, that
problem है.
देखिए, that intelligence minimum level नहीं है इंडिया में. इंडिया में maximum level है. So everybody will figure out how to circumvent it. आप कुछ भी बना लो.
We can't do much about that. Okay.
हाँ, वो तो है, क्योंकि यहाँ तो मेरे को सबसे पैसा ये अमेंडमेंट में ये समझ में नहीं आया. जो सबसे बड़ा जो चीज था, सबसे पहले बात हुआ था ये 14 डेज के मैटर में, कि द राइट टू बी हर्ड. आपने ये तो कर दिया, 14 दिन के अंदर करना पड़ेगा, शाल कर दिया मे के जगह पे. हाँ, बट अदर पार्टी को अपने राइट टू बी हर्ड का अगर मौका नहीं दिया, तो यू आर वायलेटिंग द प्रिंसिपल ऑफ नेचुरल जस्टिस. तो ये वापस कहीं ना कहीं कोर्ट बोलेगा नो 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 नो, natural justice तो होना चाहिए. It can jolly well go for a toss. It can jolly well go for a toss. So basically, what was required, instead of only taking the care of the Vidarbha judgment by doing this, you also should have provided something कि the other party could refute only on these grounds. For example, if you say default has happened, the party can only refute on default has not happened and not why it has happened or why it has not happened. है ना? Secondly, आपने आयु का deemed ये कर दिया, deemed, right? कि आयु में आपको चढ़ाना ही है, and आयु में अगर आपने बाद में what you say you have आयु gives you a notice, and if you do not confirm within 1 month, it is deemed that you have accepted, right? Now, how legal is this deeming? That is challengeable.
Challenge करो. You will
वही
find
तो
out
मैं बोल
whether
रहा
it
हूँ.
is legal. Somebody will, I'm sure.
So that's
And then
exactly what I'm saying.
Anything, any provision which says shall in any law in the country, somebody can always go and challenge कि ये गलत है. My constitutional rights are, I mean, usually that's the challenge. They affect one or the other of the constitutional rights, including fundamental rights. So the courts decide. So we cannot assume कि प्रॉब्लम हो सकता है, वो चैलेंज हो सकता है, उसमें इतना टाइम लग सकता है, तो इसके लिए हम कुछ ना करें. ये नहीं हो
कुछ
सकता.
ना, नहीं कुछ ना करे ऐसी बात नहीं है. आप करो, थोड़ी क्लैरिटी से करो, यू नो, आप करो, इस पॉसिबिलिटी को भी देख के करो कि ये हो सकता है, इंडिया में ये हो रहा है, तो फिर से ये
Basically,
लटक जाएगा,
it
फिर
needs to
से
be
ये लटक
rationalized.
जाएगा.
It needs
हाँ
to be
जी.
rationalized. 14 दिन में तो possible है ही नहीं. None of the court. So unless
Hello,
logically what
can you
happens, how
come
it
a
can be
little
done.
closer to the mic, Mr.
It
Shah?
is,
थोड़ा सा आवाज ठीक नहीं आ रहा है.
yeah. So the logically, if we rationalize these things, it can be done. And now how it can happen if the NCLT bench delegates the powers to registrar level pleading part. Why do you require judicial mind for pleadings? Why do you require time for that? Let it be handled by the registrar. And then when it comes to the argument, it goes to the court. And 14 days they pass the order. That is still a rational thing. After hearing both the parties within 14 days, they pass the order. That is how it can, where you don't require mind why court is wasting so much of time in taking the pleading, taking the dates, filing things. All these things can be done at the registrar level unless it can be it requires to be challenged. It can come to the bench. But otherwise, these powers can be delegated at the lower level. And then when it comes to the bench within 14 days, you have to pass the order. That can be a bit rational thing that both the parties are heard based on the pleadings. And then within 14 days, the order is passed. Something like that can be, rationalized. And just giving a blanket thing that it should be made shall be made in 14 days and all, it's not feasible.
Something like
And
that exists in the IBC under personal insolvency. When you have to file a report under 99, this is exactly that. And we know what is the fate of that.
Right.
The RP's report is supposed to be comprehensive on these aspects only. That is there a debt? Is there a default? Has there been a payment made between that period and this? Is the claim of the applicant correct? Broadly, these are the 4 things that are addressed in the report. But after that, also there is a rebuttal given because there are other issues. Now, the limitation is an issue which registrar level cannot decide. Remember that. Nowhere is that allowed to be decided.
Correct.
But
Adjudication
limitation
part
can be
can be done
claimed.
by the court itself. So once the preliminary issue of limitation is raised, it automatically go to the bench. Argument will never happen for the registrar. It's only the pleading part.
Only evidence, you can only provide the documentation, and that is
Correct.
broadly what is being proposed in the amendment when they say that if there is a record of default issued by an IU, no further thing is required. Nothing. No principle of natural justice or anything because it is already pre-established. That's what it means. Of course, limitation will always be there as an issue to be raised.
is the IU supposed to look at the limitation?
No. IU has nothing to do with limitation. Limitation is the concept of limitation is whether it doesn't decide your right. It only decides whether you can approach a court for enforcement of your right. Limitation is about enforceability of your right, not the existence of the right.
No, so supposing you are filing a report with the IU saying that so and so has defaulted, okay, and IU is supposed to verify and then take it on record, give the other party a notice, and let's say if fails to respond to that notice, right? Now, IU records if there is a default. And if that is the final document,
No, the IU sends a notice to the debtor.
it does.
And the
It
debtor
does.
can raise the issue of limitation, in which case it will be a dispute. IU will not record debt. Debt itself is in question. Forget about default.
So IU will only say there is a dispute, so I am not recording it. IU is not supposed
IU
to.
cannot adjudicate. They can only say, ye bola, ye likha. Bas. IU has no role to decide.
Okay. चलिए ठीक है sir, you proceed. I think you were feeling lonely, so
No, I am not.
thinking
I am.
that
No, I would like
that
to.
nobody was listening to you, so चलिए बोल दिया अभी हम लोग अभी आप continue करिए.
See, today's session, our topic is limited. We more or less come to the end in a way. So I said, ठीक है, time बचा है तो अपन
After you have
शायद पे
finished, you can
चर्चा कर
start
लेते
with.
हैं.
After you have finished your topic, given topic, you can
Yeah,
start
I got
2:30.
only a few things left. I will just finish that.
You
Okay?
can start 2:35 and you can pass 3 hours on that.
Yeah. So CP requirements, some changes are made. Basically, the relief given because of COVID is partially going to be withdrawn from the next calendar year. Okay. So this will be from 2026 calendar year. At least 40% of your sessions which you attend, continue learning sessions for getting credit of CPRs have to be in person. In person here actually means physical. Okay. Because even virtual is also in person. Then it goes to 50, and finally from 2028 it will be minimum of 60%. And this table 2, again in the same section in that guideline, now distinguishes the CPRs that you can get if it is a program by IBBI or an IPA. So if you get 3 hours, if it is for by IBBI or an IPA, you will get only 2 hours if it is conducted by any other eligible body with whom an IPA may or may not be associated. IBA, BI, or they may, but you have to get permission to do that. In such a case, you get 1/3 less. That is the if it is in person, and half if it is virtual. So if you spend half a day here today, you are going to get probably 2 hours because this is by an IPA. If it was conducted by any other entity who is also authorized to, I mean, whose that session is recognized for CPR, then you will get only 1 hour. Okay. So this is the changes in the CP guidelines. Okay. I was told to cover new CIRP forms also, but they are pretty mechanical. I don't know what to really cover in that because I found them largely self-explanatory. Anyway, I will quickly run through that. If anybody has a question, we can address that. Okay, there were 7 forms earlier, if I can recall. They have become only 6, not 5, though the number is 5, but one form has an A and a B. So there is a reduction. There are changes in what is the coverage in each form. The significant change is now the submission time is more or less the same in all cases. That is on or before the 10th of the succeeding calendar month. Except for, of course, resolution plan, liquidation or closure. Here the timeline is 7 days from the date of order. In all other cases, on or before the 10th of every month. There are subject-specific forms, there are timeline-specific forms, and then there is a monthly form also. So that is it as far as the forms are concerned. As I said, nothing much in that. And so we are at 2:17. So 1 hour 17 minutes. We have a significant amount of time. And if anything is left over from yesterday by chance on the amendment bill, we can take that up, or any other point from an IBC, either the code or regulations. We can have even a common general discussion for those who want to participate. And please share experiences, it's not only about questions, but it will help all those participate.
In the amendment, particularly on the liquidation side, where they have further shrunk the timeline for liquidation, whereas the experience of liquidation says it goes on for years together, many a times. So, very debatable as to what is the legislative intent. Because let's say you have a big company, very big company, let's say Reliance Naval or some big company, and one of few of the companies that I am also handling. There are multiple ED cases, so many other things. Assets are attached. How are you going to dispose those assets within 180, maximum 90 days? And after that, the COC, which is now obviously it will be COC monitored. So COC has to decide what to do with the assets. So what is to be done with the assets? There is no guidance. So is the legislative intent कि ठीक है 180 दिन प्लस 90 डेज में आप कोशिश करो, उसके बाद whatever is pending, you just dissolve the company. Is that feasible? Assets
That
may
is
be...
not, that cannot be. This was based on the first day itself. Because
so what are they saying? Because they
No,
should have,
see.
ideally.
No,
If-
now what? Okay, this is a drafting error, no doubt about it. Okay, it has not been thought through. It can happen. It can happen with the best of us. We can make this mistake. So the consequence of not completing in 270 days needs to be specified by way of either an amendment in the amendment itself, or by delegating further to IBBI to clarify it by way of regulation what happens next. Okay. I mean, there could be various options. It could be that then, the next extension will require these requirements,
so
conditions.
precisely, the logically,
Or
what
they could say
see,
कि ये liquidator बेकार है, दूसरा लगाओ.
नहीं वो तो अभी भी बोल सकता है 180 दिन के
I'm
बाद
just,
वो तो डे वन से बोल सकता है, ठीक है. बट माय सबमिशन इज यहाँ पे सिंस दे हैव पुट इट ऑन द सीओसी, ओके.
No, they have not put it on the COC.
अरे सर क्या बोल
There
रहे
is an
हैं?
assumption. Somebody who is explaining.
सीओसी मॉनिटर ना, सीओसी मॉनिटर.
Monitoring. Listen, that's a misconception that where the act says shall, that the COC has a power to override the act. It doesn't have.
No. I am not asking the COC to override. All that I am saying, this power should have been given to COC to authorize the liquidator to file for an extension, further extension, before
It
the
might come,
NCLT, with certain reasons. Because अभी क्या है, मुझे लगता है IBBI को किसी तरह से लगता है कि भाई liquidators अपनी खुशी से liquidation को लंबा चलाते रहते हैं.
नहीं, जो भी लगता हो, see,
नहीं है.
let's again come back to this, that everything need not be in the act, because regulation क्यों करते हैं? Because they can
ये
respond
एक्ट में
to.
होना जरूरी है.
नहीं,
बिकॉज
listen.
यहाँ पे शाल लिखा हुआ है.
नहीं, that part is, I told you, it's a drafting error. It is. There is no doubt about it. Because while you can say shall for resolution, because there is a step next. If CRP fails, liquidation is already provided for. But if liquidation fails, there is nothing after death. Rebirth देना पड़ेगा, either that or So liquidation being corporate death is the end line. So that is a mistake. There is no doubt about it. Once we recognize it's a mistake, they will also recognize it. It will be attended. Let's assume that. If they don't, tab ka tab dekhenge. But in terms of what to do next in the actionable part, okay, the implementability part, I'm sure that it will be delegated to IBBI to address it by way of regulation. See, if you look at what was originally, there was no time specified for liquidation in the code at all. It was in the regulation which said it shall be 1 year extendable with permission of the NCLT.
देखिए ऐसा है, if you see, to the best of my knowledge, जितना थोड़ा मुझे मालूम है, वर्ल्ड वाइड कहीं भी ऐसा कोई लिक्विडेशन पे बार नहीं है टाइम का, ठीक है? फॉर द सिंपल रीजन यू हैव टू अल्टीमेटली फिनिश एवरीथिंग. फाइनली डिसॉल्विंग द कंपनी के लिए ऑल लिटिगेशंस, एवरीथिंग नीड्स टू बी finished, not only sale of the assets. Assuming you finish the sale of the asset, still there are litigations which are pending against the company, or the company has initiated some litigation or some kind of a claim from government, something has to come. जब तक वो आता नहीं है तब तक आप लिक्विडेशन को खत्म नहीं कर सकते हो. सेम वे PUFE जब तक वो खत्म नहीं होता, आप बोल रहे हो कि अजाइन कर दो NRRA में. आई डू नॉट नो कितना गया है, मेरे तो एक भी नहीं गए. मैं तो कितनी ट्राई कर रहा हूँ.
NRRA में काफी गए.
PUFE प्योर PUFE ट्रांजैक्शन कितना देते हैं लोग?
Is now the default option is NRRA.
No, I have tried. What happens?
No, NRRA need not be to a third party.
हाँ, so मेरे केस में क्या हो रहा है?
In most cases, NRRA is now to the creditors.
हाँ, so now my problem is the creditors are not agreeing.
That will happen. Okay.
हाँ, तो अब I am stuck. As a matter of fact, in one case, they said the case is very strong. You continue fighting. We will contribute more money. They actually put more money for me. Then तो आप order लेके आओ पहले. Lawyer का पैसा मेरा खत्म हो गया था. So I said, Baba, I have run out of money. How can I pay from my pocket? They actually gave money. They said, order leke aao. We have not hired.
That's not wrong, na, by itself.
That is absolutely not wrong. But the problem is, on the same hand, if my regulator keeps on saying, कि तुमने close क्यों नहीं किया, मैं क्या बोलूं?
No, but the Act even today provides for closure of the process and PUFE to continue parallelly.
To continue by whom?
I mean, if the creditors and the liquidator or RP agree to continue, what is the problem?
No. So you have to dissolve the company, create an entity.
That can be done, and liquidator can, as a representative, continue as long as he is willing to continue and being funded for it. Funding is the issue, no?
Not only funding is the issue, time is the issue, liquidators. So what happens when you say as a liquidator, कि ठीक है, I will pursue, give me some fee. Okay, there the discomfort is there. There, नहीं आपको तो मिल गया, asset बेच के आपको मिल गया.
See, fee is a common issue with different assignments. We know that, and we also know, equally importantly, let me tell you, when there is a liquidator who takes over who is different from the RP, तो RP का fee वो liquidator देता नहीं है.
अच्छा, I want to raise an issue.
कोर्ट में जाना पड़ता है.
Santuda, I want to come in here.
हाँ, please.
As of date, in section 12, the CIRP, the time period is 180 plus 90 plus 64 exclusion. There also in section 12, subsection 3, the word used is may. The NCLT may give you 90 days extension. How many of us are finishing CIRP 330 days? We keep on asking extensions and NCLTs keep on giving. So here also you can approach NCLT second time, third time, fourth time.
सर यहाँ तो शाल लिखा है ना, not more than
सर
that.
यहाँ आपको शेल लिखा है, NCLT के में प्रोविजो में लिखा है. पढ़िए सेक्शन 54 सबसेक्शन 1 एंड प्रोविजो NCLT के लिए में है. वहां पर भी शेल लिखा हुआ है, आपको 180 डेज में फिनिश करना है, वहां भी शेल है. CIRP also section 12 says you shall
नहीं मैं
finish in one you
मैं
shall
180
finish in 180 days.
सर
Please
सर मैं
understand,
आप
please understand, timeline under section 12 and 54 are same. There also it is said 180 days plus extension from 90 days, which is May on NCLT. Here again it is 180 days. You said finish liquidation, dissolve it, file an application, and you may move an application for extension. In 12, you need an approval of COC. In 54, you don't need an approval of COC. That's what Ravi was saying. That COC shall only supervise. COC is not having the same controlling power as in CIRP. That's the reason in 54.1, you don't need a COC approval for extension.
Sir, my submission was on the Amendment Act, proposed Amendment Act.
Exactly, that's
उसमें
what I'm
अगर
saying.
आप
The proposed
हाँ
amendment act is not doing anything other than aligning section 54, subsection 1 with section 12. That's it. The jurisprudence that prevails on section 12 would per materia apply to section 54, subsection 1 also. There is no difference between two sections.
So you are saying when they have said that 180 days plus 90 days and no further,
They have not
that
said no further.
देखिए
Where is
आप
the word no
लिखा तो
further?
है
Sir, आप
आप एक
समझ
बार
नहीं
उसको
रहे. The
स्कैन
जो
उसको एक बार
दादा
किसी के पास है तो
दादा
स्कैन
मैं
ये
आपसे
करिए
कह
ना
रहा हूं जो 54 में लिखा है वो 12 में लिखा है. Are you applying further in 12 or not? You are. So you do apply in 54 also. Where is the problem?
Let
नहीं,
me just
आप
share 1 second.
हाँ
1
प्लीज
second. Hold
शेयर
on,
ना
hold on,
प्लीज
hold on.
शेयर ना
Hold on. I will
please
just
share.
share one provision which will, and along with that, the thing.
That
Now,
amended
this is,
हाँ
no, this is the proviso which extended the period from 180 plus 90 to by adding that additional 60 days. Okay. Now, see the wording provided further that the CIRP shall mandatorily, okay,
Shall and mandatory.
and what did the Supreme Court say? Mandatory for COC and RP, not for NCLT. There can be nothing which imposes a timeline on any court in the country because that is an interference in the independence of the judiciary. At the same time, in the same judgment, the Supreme Court also said, but that does not mean that NCLT or NCLAT can keep giving extension. Ordinarily, they should not. That is
राइट. तो अभी जो अमेंडेड है अमेंडमेंट प्रपोज्ड है वो थोड़ा एक बार दिखा दीजिए.
नहीं, अमेंडमेंट जो प्रपोज है वो भी दिखाता हूं.
हाँ वो दिखा
इसका भी
दीजिए. उधर ही
इंटरप्रिटेशन
कंफ्यूजन.
यही होगा कि ये मैंडेटरी लिक्विडेटर सीओसी और सीओसी के लिए है, बट इफ सर्कमस्टांसेस यू कैन जस्टिफाई, then you will get a second extension, third extension, fourth extension.
एक बार दिखा दीजिए ना. मेरे को थोड़ा वो लैंग्वेज में ऐसा लग रहा है कि वो ऐसा नहीं है.
नहीं, it is similar language. It shall not be done more than ऐसा ही है, but बताता हूं. Okay. Just a second. Give me a second.
Clause 33 of Amendment Act.
33
Three.
क्या पेज?
हाँ. Page I don't know. It's clause 33 of Amendment. Page 16. Page 16.
16 ना?
Yeah.
One second now. Okay, this is the one.
Hmm.
The adjudicating authority may, on an application by the liquidator, along with sufficient reasons, extend the stipulated time by such period as it deems sweet, but not exceeding a period of 90 days.
So are you saying multiple applications can be made? अभी जैसे 6
एक
महीने
मिनट
नहीं,
शांतनु
there
दादा
is-
will come to एक मिनट
हाँ.
will come to that just a minute. Ravi ji,
हाँ,
can you also say that 12 which is that still open on your system?
which
Section
one?
12.
Section 12. हाँ,
Yeah.
one second.
Please open it. Share it. Okay.
Yeah, this is the one, 12. The proviso. Okay.
Read first proviso of subsection 3.
Provided that any extension of the period of CIRP under this section shall not be
Be
granted
granted more than
once.
once. Here the word used is shall. That NCLT shall not grant you more than one extension. They
Yes.
grant you 5, 6, 8, 10 extensions. Now
Now,
compare
what-
section 12 and 54. The 54 is more
right.
liberally
The
worded.
difference is that in a CIRP, you can make it mandatory. एक ही बार मिलेगा. Because CIRP is supposed to be a short-term, special, calm period, a last chance to resolve. You can't say that in liquidation because उसके बाद क्या? Because in CIRP, no extension, go to liquidation. That is the step. In
What I'm trying,
liquidation, that is the problem.
what I'm trying to highlight is CIRP में shall लिखा है, उसके बाद भी आपको extension मिलते हैं. More than
Because
multiple
Supreme
extension
Court
मिलते हैं.
said shall is for the RP, not for
Yes.
the NCLT.
So in liquidation also you'll get more than at a time you'll get 90 days, but you'll get multiple extensions.
By practice.
Yes, by practice.
Because for COC, so basically that means जैसे एक्सटेंशन CIRP में अप्लाई करने के लिए हम लोग 66% वोट लेते हैं COC से एंड along with the resolution of the COC अप्लाई करते हैं. अब लिक्विडेशन में वही करना पड़ेगा.
नहीं सर, आपको अथॉरिटी है, you don't have to go to COC. You have the authority. 54 but does not talk of COC approval.
नहीं वो रेगुलेशन में आ जाएगा, डोंट वरी.
Let us see what comes in.
वो सब आ जाएगा रेगुलेशन.
आ जाएगा तो ले लेंगे.
नहीं अरे
नहीं लेने में कोई हर्ज नहीं है, लेने में कोई हर्ज नहीं है. मुझे सिर्फ इतना ही था कि अगर एकदम ही बार कर दिया, देन जस्ट लाइक घंटी सर वाज सेइंग, उसके बाद क्या?
तो
That
नहीं हो
should be
सकता.
clarified. हाँ.
See, when the interpretation of a law results in absurdity, then it has to be interpreted in a manner which is reasonable. It can't be an absurd conclusion. So it will be, now it is only an amendment proposal. ऐसे बहुत सारे act आए हैं where such things have come to the notice at the committee stage. You look at the JPC. Now when BLRC drafted the law, the Joint Committee of Parliament made significant changes in that because they found in implementation there are problems. So similarly, यहाँ भी होगा. The parliamentary committees generally do a good job. Let's give the credit where it is due.
So good afternoon. This is Minita. Sir,
हाँ जी, बोलिए.
I just wanted to understand that in the amendment bill, there's an amendment in section 18 regarding the claims to be verified by the RP. Now they have put the ounce of part of the adjudication that the amount has to be verified by the RP, IRP or RP as the case may be, IRP, sir. So, how do you relate this vis-a-vis the RP's duties to be completed within 14 days and file the list of claims with the NCLT? I mean, within 30 days, but within 14 days, I have to verify and collate it.
Right.
So, will it be
Because
possible?
how is it different? What is the difference?
Sir, erstwhile when we were collating the claims, and suppose there are certain claims which were subjudiced with certain with the particular bank, or with the, say for example, that GST department has given me the notice and they are just assessing it, and then I would say ki nahi, this is, unless and until you give me the exact amount of the claim, I cannot verify it and I cannot accept this particular claim. There were n number of claims. A claim under
Yeah,
arbitration.
understood, understood. So, okay. Now, the amendment that is proposed is actually aligning the code with the practice. It is because there were cases, and many, not few, where disgruntled claimants would go to NCLT and say, RP, once I file a claim, RP has nothing else to do except write the figure in an Excel sheet and fill it. He cannot even check. Collating does not include verification. This was a very big problem in terms of number of cases, not one. There must be at least 200-300 of such IAs would have been filed across the country. What the amendment proposes to do is that which was always understood, that verification, because that is there in the regulation. By the way, regulation uses the word verify. Code does not. Now they are bringing the word verify into the code, nothing more. They are giving the regulation the backing of the act.
Understood.
No
sir.
change in situation.
Okay,
Nothing
okay.
changes. It is
Okay.
just clarifying a situation, because most amendments in the amendment bill are clarificatory in nature. They may not call it that, but they are actually clarifying situations, addressing issues which have arisen because of contradictory judgments maybe, and also what you call aligning with practice, where the practice has been better than the code. So all things have been taken.
Thank you, sir. Thank you, sir.
Anything else?
Sir, one of the query I have is, if owner has given development rights to the corporate debtor,
Uh-huh.
in that situation, if the corporate debtor when it goes into CIRP, whether the owner will be considered as operational creditor or other creditor. I'm confident there are judgment which says that he is not financial creditor. But
See,
then,
okay, there are conflicting judgment, no doubt about it.
hmm,
There are many which say that the owner of the land who how is he being paid matters, okay? In most cases, they say such percentage of area, whatever it is in terms of number, will be mine as a consideration, and I will do whatever I want to do with it. Then tribunals have generally held that you are like a co-investor because you are partaking in the profit or loss, as the case may be. So even though it is not it may not be a company or an LLP, but it is a loose AOP. Two people have come together, association of persons. You don't need to be registered as an entity, but you are still sharing the outcome of that business venture. It's ultimately a business venture. Okay. So that is the large body of judgments are in that line. The majority. There are cases where there is no such kind thing. There is an upfront or a crystallized amount to be paid for transferring the development rights. Okay. Now here there is a question mark. What type of creditor are you? Okay. Now a financial creditor, if you look at financial debt, you have to give money. Here you are not giving any money, right? Money in time value of money, not a property, but money. You only have to receive. Now, what you are giving is a development right. Is it a goods or is it service? If one of these two, then you are an OC. If it is not any one of these two per se, then you are the residual category, Form F. Okay. Now, in terms of 53, there is no distinction between these two, by the way. 53, an OC and a Form F are both under that any other. There is only one residual claimant. So they won't one will not be adversely affected by this. However, such a creditor may not get the benefit of the minimum liquidation value clause which is there in the resolution plan. Resolution, liquidation में वो problem नहीं है. Resolution plan. Because in resolution only, there is this concept of FC, OC and others. In a liquidation, of course, there is unsecured financial creditor at the bottom, but all secured creditors, whether financial or otherwise, are at the top.
Correct.
So it depends on the situation कि क्या होगा.
So
Now
if there is a
one
joint development agreement where revenue sharing is there.
नहीं,
So
joint development agreement in writing with a revenue sharing, what is it? I mean, be fair. Let's say, forget about IBC. क्या है? ये तो partnership. You ask any person, common sense से बोलेगा, it is a partnership. That जो मिलेगा उसमें हम share करेंगे. Now the sharing can be of profit, sharing can be of revenue, or sharing can be in kind in terms of the output of that business. But it's still sharing. Whereas a supply of money is not dependent on the outcome of the business. If money is given, there is a term you have to repay it. That's it. Nothing. There is no indeterminate figure there. Similarly, if you supply goods or services, there is no thing maybe agar hua to, in general. So that is why these two are different. And whenever the word sharing comes, I mean, sharing se to shareholder aaya hai. Shareholder share. Okay.
Right.
So it will be an investor.
Right.
Should be. But again, there may be certain specific situation where the wording is such that even though it looks like, I mean, the heading is joint development agreement, but actually the fellow is selling it upfront for a certain consideration, then it is not a joint, sharing. Then
Goes
it is
by the spirit, not by the letters.
the text of the entire agreement has to be read as a whole, not just the heading.
Correct.
Haj. Any other? There is one judgment on this real estate where the provider of the land, the statutory authority, has been treated as a financial creditor, secured financial creditor. There's only one case like that.
That is, I think, MADA and MIDC case is there. One case is relating to that. The government regulatory authority providing the
regulatory authority is different. Land providing authority.
Land providing authority. Sorry.
So where this authority has sold the land, but has to receive a certain amount of payment because it was an installment payment, the residual portion has been held to be a financial debt.
Right.
So there is only one, as far as I know, till today. But it could be more tomorrow.
Because we decided not to challenge it. I have decided not to challenge it.
You have decided. I know.
Also, sir, I would like to know your views about the home buyers. Whether can they be considered a secured creditor in any way? There is one NCLT judgment on that. Because there is a security interest when they execute the agreement for sale. They are having the relevant right over the FSI, related FSI of the property.
See, ऐसा है कि security interest as such, in general, can be created in various forms. By act of parties, by operation of law, and by deeming fiction. Okay. Now, the third part, deeming fiction, is what was used firstly by the Supreme Court and then by Parliament to classify allottees as financial creditors. Customers are not financial creditors. Okay. What allottees or home buyers are giving is advance towards buying something, not money to receive back money. A financial debt is money given where what comes back is money.
Hmm.
But this is a deeming friction, the third category where it was.
Hmm.
Similarly, under RERA, I think it is section 11 read with 17 or something. There is an indirect security interest, in the sense it is not a security interest that is created. It is a bar to create further security interest. What RERA says is that if there is a registered agreement for sale, which is mandatory if 10% or more of the consideration is taken by the seller, then the duties of the seller, the developer, then after that, the developer cannot create any other security interest on that property.
Hmm.
After, okay?
11.4H.
Ha. So prior to that, he can. So at the beginning of a real estate project, which is usually what happens, and when the developers take project finance, mostly
Hmm.
from any bank or a financial institution, whatever, they do create security interest in favor of those lenders, and they are prior in time. After they start booking, and only if there is one, that 10% threshold has to be, crossed. And then, of course, registered agreement for sale is an evidentiary value. The question is, if the developer doesn't do it, then what is the right of that? That's a separate issue. But if that is done, then subsequent to that, no additional security interest can be created without the consent of those allottees. Of course, with
Correct.
consent, any other charge can be created. Section 48 Transfer of Property Act. Okay. Now, the interesting thing that usually comes, okay, in most states, not all, but most states in India, when you execute a registered agreement for sale, agreement for sale which you register, you have to pay the stamp duty in full on the total consideration. Maharashtra mein to hai. That is something many buyers don't want to. For a very short-sighted thinking, whatever that 5%, 6%, 7%, they don't want to pay at that time. They want to wait till it is over. Tab denge. From one angle, it makes sense, in the sense, tomorrow's money, why should I pay today? But they are losing this protection by their own act. And that is the majority of cases. If the buyer insists कि मेरे को register कराना है, there will be rarely be a developer who will refuse to do it. So the protection to home buyers, which ought to be there, which is provided for in law, they lose out on it because of their own short-sighted thinking and also lack of knowledge. They don't understand this thing.
But where there is a registered agreement for sale, there security interest is there, right? There
Barred. Further security interest is barred.
Yeah, further is barred.
So it is
I have come across a situation where home buyers wanted agreement for sale to registered developer was not able to register because there was a joint development agreement with some another partner, and he was not willing to cooperate because he said that partner is not getting the revenue sharing. So they both had a dispute.
That can happen, and that is what courts are for. That means there is a dispute preventing the exercise of your right. That is when you go to court.
Thank you, sir.
Okay. I assume no further questions. So, yes, Rakshu, from my side over, unless somebody has a question. ICSI, anybody?
They also come back at 6 hours.
Yes, I said there are no further questions from anybody. As far as we are concerned, we are done for the day.
So shall we conclude, sir?
Yes, from my side over, unless somebody has any question, we will address it. Otherwise, we can.
I have one suggestion, sir.
Hari.
For real estate side on home buyers, many matters we handle, whether in capacity as AR or IRP or RP, home buyers are not fully acquainted with the IBC law that we all are aware. And that is where, the rights are required to be protected. Now, one of the suggestion which I had is, once the CRP is admitted, how AR is appointed, AR should, which I do it as a voluntary process my end when I am appointed as AR. I train the home buyer about the law, about their rights and duties and obligations. There are very few provisions, but they need to be educated about that what are their role, as a home buyer in the COC and what is expected from them. So if AR, if there is some law that can be created on this, it will help a lot to the home buyers. A basic, maybe a 2-hour session, but that will help all the home buyers to understand what is expected from them. Their insecurities can be resolved because they are not aware. The insecurity comes from the fact that they are not aware what will happen to their fate. So, what are the risks involved? What are the expectations? If I do it voluntarily, that is different thing. But if some law relating to that to educate the home buyer, because they have important role in the decision making in COC. So, if that voting is done wisely, it will help everyone, including COC and the whole CRP process.
True, but while the good suggestion, it has one problem with it. We are assuming that IPs don't do the job unless it is a law, which is a very bad reflection on our profession as a whole. I hope people understand that part too.
Yeah.
And some of these amendments that are proposed and the deliberations of the parliamentary committee, they have raised a lot of questions about the competence of IPs, the conduct of IPs, the capability and knowledge level of IPs. And more powers have now going to go further to COC because people have lost faith in the ability of IPs to do a good job. And one of the reasons is this mindset कि जब तक कानून में नहीं आता मैं करूंगा नहीं. So, part of life. Okay. ठीक. Yes, madam. Over to you.
Thank you very much, sir, for your valuable suggestions and nice presentation on the topic. Thank you very much, sir. Sir, you are requested to kindly share the PPT.
I will share it with you. Yeah. Okay. Thank you.
Thank you.